Mr. Falana is here with us this morning, he's promised that there's some interesting conversations to have with us this morning. He's a senior advocate of Nigeria, and he's also been in the trenches fighting for the liberation of some liberty of our democracy, so to speak. Thanks for joining us this morning.
Thank you very much. My pleasure.
First of all, what's your take on this? I don't want to make assumptions.
Well, I've been part of the struggle for public accountability in the country. And that is the way I look at this judgment, is going to advance the struggle for public accountability. If Nigerians can own the system, if Nigerians are prepared to monitor the activities of local government officials, state government officials, and federal government officials, and that is the only way we can have political stability and security in our country.
If I will ask you, before we go into the details, we've had every attorney general of every state has been a legal practitioner.
For sure, that's in line with the provisions of the Constitution.
A good number of them also senior advocates.
Yes.
So I'm wondering, because they even went to court to question why, whether or not the AGF has the right to even bring the matter on, and then to even, I'm wondering why it needed to get as far as the Supreme Court, when the law and the Constitution, according to the Supreme Court, is clear.
Well, number one, this is one of the very rare public interest litigation, the public interest, cases that the Attorney General has filed in court. And I say it's a good development. But while not apologizing for our colleagues, we operate in an atmosphere of impunity. There are not less than 5 judgments of the Supreme Court and several judgments of the High Court and the Court of Appeal to the effect that no governor has the power to dissolve elected local government officials. But that occurs on a regular basis. Today, out of 36 states in the country, 22 governors have sacked local government officials and installed caretaker committees, contrary to the stipulation of Section 7 of the Constitution, and in flagrant disobedience to several judgments of the courts. Again, because the Nigerian Bar Association has not put in place a mechanism for dealing with lawyers in public office who defy the Constitution or who fail to give appropriate advice to the federal government, state government, and state government.
Forgive me, Mr. Falana. And it will sound like maybe I'm just trying to make excuses, or I'm just pulling on strings. But I just want to know, they are legal practitioners. They are senior advocates of Nigeria in some cases. And a good number of them have had situations where absolutely no reason should be given to the effect of what you've talked about. Is the Constitution or any of our laws in any way ambiguous?
No. Where there are laws that are ambiguous, but not this one, on local government autonomy.
Because some of them
Section
have said,
7.
My apologies, some of them have said, both governors and some legal practitioners have said that the Constitution, makes room for the president, the governor, but no particular specification for the local government chairman as part of the reasons why they have, obeyed the Constitution in breach of this particular.
No, I'm not sure that argument is correct. Everybody, every lawyer in Nigeria is aware of the provision of Section 7 of the Constitution to the effect that the system of local government in Nigeria shall be by democratically elected councils. I'm not sure this was captured by the Supreme Court. Unknown to most Nigerians, Section 7, I think subsection 6, provides that in every state, the House of Assembly shall make a law to facilitate the allocation of funds from state government to local government. That's apart from money taken, allocation from the federation account. The state government is also required under the Constitution to give money for the development of local governments, which is why the money from Abuja shall pass through a joint local government joint state local government account. Now, furthermore, Section 7 also provides that in every state in Nigeria, the House of Assembly shall make a law to enable local government to participate in the economic planning of that state. And as a matter of fact, there shall be an economic board in every state, people by state government officials, local government officials. But these provisions are ignored by state governments. Ignored by state government. And again, contrary to the argument of some of my colleagues, the Supreme Court has rewritten the Constitution. The money is supposed to be paid into a joint state local government account. What that provision is saying, by the way, is that the money will pass through the joint local government state account to the local government. Section 6, subsection 6 of Section 162 says the money shall be paid from the federation account to the joint state local government account. From that account, it shall be paid to each of the local government in every state. What the Supreme Court did say yesterday is, having regards to the combined effect of Section 7 and 162, and having regards to the evidence produced by the Attorney General, adduced by the Attorney General of the Federation, that this money is being diverted. The money gets to the joint account, but it never goes to the local government. The Supreme Court now ordered, henceforth, the money shall go to the local government.
So the Constitution has to be reviewed to the effect. That's exactly what you're saying right now.
No.
Because just as you said,
once the Supreme Court has made a pronouncement, yes, that is the law. That is the law. That is the law.
So the
Constitution says local government officials shall be elected. But we now have 22 states. People by unelected officials and caretaker committee members.
Now, the
Constitution also says in Section 162, the money collected from Abuja, the allocation, statutory allocations of local government, shall be paid to the local government through the joint state local government account. But the money that will be paid to the joint state local government account either simply disappears, is cornered or diverted from there. It never gets to the local government. In fact, I can give you an instance, and I'm not sure whether the Honorable Attorney General referred to it in the case. When, a few years ago, the London Paris Club refund was made to local government and state government. In the majority of the states, the allocation, the refund for local government never got to the state. Some governors gathered in Abuja and directed the Accountant General of the Federation to pay the money to nominated accounts. Oh yes, and that was how the money was diverted. And I know that the EFCC is investigating this diversion. So it's not in the interest of the governors, it's not in the interest of our country that money meant for development is diverted.
Well, there are so many other issues to raise with you on this particular matter, Mr. Falana, because on the one hand, we have this, and according to the Supreme Court, it has to be implemented immediately. And there are questions around, so how do we operationalize? So we'll get to all of that when we return from this break. Please stay with us. Well, before we go into, by the way, thank you for staying with us. Before we go back into a number of other issues, Mr. Falana, you are not unaware of the comments of a former governor of Delta State, James Ibori, who says that it's a severe setback on the principles of federalism. What do you think he means by that?
I think with profound respect to Chief James Ibori, I think the argument is a bit contradictory. When we had several in the 50s and in the post-colonial era, nobody was going to Abuja to collect money. Every region depended on its own resources. And those were the, that can be described as the golden era of cocoa production, cocoa in the west, groundnut in the north, and palm kernel in the east. Today, everybody goes to Abuja. So for me, it's distorted federalism. So you can't collect money from the central purse, money likely made from the Niger Delta. When you now get to your state, and you ask to give the allocation of local governments to them, you suddenly realize this is a setback for federalism. It's contradictory. It is either, I support, establishment of local government by state governments, that we have to review the revenue allocation formula, we have to review the entire structure of the country. But for now, what does the law say? As opposed to what the law should say. Yeah, so that's simple and straightforward.
You don't see it as what he calls an interference of local government administrations by the federal government, because the Constitution also provides, just a second, the Constitution also provides that the supervisory authority of local governments is vested in the Houses of Assembly.
No, the House of Assembly shall make the law.
Okay.
For their administration, for their finance and whatever. The local governments have been were created by Decree 24 of 1999, otherwise called the 1999 Constitution. When it suits members of the political class, the Constitution is a beautiful document. But when you are now asked to practicalize it, operationalize the provisions, we then remember this is not a federalism. It's not true federalism. So what is important at the end of the day is how to account for the resources of the country.
So how? Just a second. My colleagues are coming in immediately after this question. Now, one of the issues that have been raised is that of accountability, which you talked about. State governors are having, had been having a field day and with not as significant enough accountability as would be expected. Given the quality of people who are interested in local government administrations now, so what wonders? What's the accountability mechanism in the event that now that the local government administrations have the authority to spend all the money, what's the accountability infrastructure?
In the first place, the judgment can be said to be the beginning of a long-drawn battle, political battle, legal battle. And as I did say earlier on, today, out of the 36 states of the country, 22 have caretaker committees appointed by governors. So nothing stops the members of those caretaker committees, even when they are paid the money directly, nothing stops them to say, sir, this is the money. What do we do with this? 2, in the remaining 13 states, 14 states, the elections conducted by state electoral commissions, state independent electoral commission, are the worst elections in Africa. These are elections today. No serious member of the opposition in any state participate in local government elections because the results are already known, predetermined. So if you waste your money and your time and resources and energy, you already know the result. The candidates of the ruling party, all the chairmanship candidates, all the councillorship candidates will be declared the winners in order to ensure that nobody raises a query at the end of the month when the money comes. So We haven't addressed this yet. 2, for the people of Nigeria, I think this is an opportunity to reposition themselves, to ask questions at the grassroots level. If a chairman wants to risk his liberty by handing over the money to somebody, too bad for him. Because at the end of the day, he or she will be held to account. And that is why Nigerians must also take advantage of the judgment of the Supreme Court to begin to ask for the budget of each local government, disbursement of funds. After the payment of salaries of local government workers, what happens to the remaining money? I think this judgment has provided Nigerians the opportunity. Because right now, we only discuss the budget of the federal government. We don't even discuss the budget of state government, including Lagos, that is said to be the 5th largest economy in Africa. So I think this judgment is a challenge to Nigerians to demand for the budget of each of the 774 local governments. Secondly, I expect, because the Supreme Court ordered that the judgment is with immediate effect. What that means, I was speaking with the officials of Algon yesterday night, and what they are going to do is to collect the accounts of the 774 local governments and submit them to the Accountant General of the Federation, so that with effect from the end of this month, money meant for local government will go to them directly.
Chairman, Kayla. Chairman.
Advantages to the judgment, because many say, in fact, it will afford them the opportunity to even begin to think about contesting elections as local government chairmen, since they've got their funds directly. But there are several schools of thought out there. Some argue that the Constitution does not vest the Supreme Court with powers to invalidate or expunge any part of the Constitution. The judgment yesterday, they argue, appears that that is what the Supreme Court has done. They ask, what then happened to the provisions of Section 162, which talks about the creation of the states and local government account, if the federal government is going to pay directly to the states, to local governments?
Chamberlain, this battle actually started in, I think in 2004, when the president of the country, President Olusegun Obasanjo, ordered that the funds of local government in Lagos State be confiscated on the ground that the Bola Tinubu administration had created a new local government. Actually, it was another directed at about 4 state government, but it was only Lagos that stood its ground. And the Lagos State government won the case in the Supreme Court, i.e., that the president has no powers to order the confiscation of the statutory allocation of local governments in Lagos State. But the judgment didn't say that state governors shall have the power to seize the money, which has been the case. Again, in 2005, thereabout, the National Assembly made a law for monitoring local government funds in the country by appointing monitoring committees. Again, the state government went to the court. All the state government, the case of Attorney General Abia State and Attorney General of the Federation. And the Supreme Court said that the federal government had no power to monitor the funds meant for local government, because the local government are democratically elected. And so what we now have this time around is that since 1999, money meant for local government have been diverted in the majority of the states in the country. And so this was what informed the decision of the federal government this time around to ask the Supreme Court to intervene. And the Supreme Court has intervened. It is now left for the Nigerian people to actualize the terms of the judgment to the benefit of our people.
Good morning.
And then the Constitution has not been violated.
I just need some clarification. That money, does it still go into that joint account?
No, what the Supreme Court is saying, the joint account, the money was not supposed to sit in the joint account. It was supposed to pass through the joint account, because in that joint account, if you read section 162 and 7 of the Constitution, the money given allocated to local government by the state government should also go to the same account. But this time around, the state government do not allocate any money to local government. So what is the purpose of putting that money in that account? Hence, the Supreme Court has said, having regard to both sections, by the combined effect of section 7 and 162 of the Constitution, local government shall henceforth have their money directly paid to them from the federation account.
Okay, so that actually brings me to some of the issues that are being raised by people who are not very happy with this court judgment. One of them is the fact that this now gives the federal government ability to interfere with local governments, pushing the states out. In fact, one of the words that we used was political leverage. If now you know that your funds are coming to you directly from the federal government, the same issue that we said the state governments were doing with local governments, that the federal government will now be that meddlesome. And this, they say, would affect the balance of power, especially in states that are not part of the ruling party. What do you make of this?
No, that will not be possible. Again, as I said, there are two judgments. Attorney General of Lagos State and Attorney General of Abia State against the federal government, where the Supreme Court ruled that the federal government cannot touch the money meant for local governments in Nigeria. So what is going to happen now? It's not that the federal government would decide what should go to a local government. The nexus between the federal government and local governments now, it's not about bypassing local government. It is that money meant for local government in the federation account shall be paid to them directly. That's all. It's not that the federal government will have the power to touch the money, to seize the money, or divert the money.
If the issue is this local government accessing the money, as you will understand it, so what is wrong with this option where since the joint account still exists, if money goes into that account and then the law says the states, LGs have to receive those funds directly. So if it still goes into that account and then the LGs can access that account directly, in the event where a state tries to give any local government person directive and say, well, this money is here, do this or you won't get the money, a local government chairman by this judgment can say no, because they know that if the states don't allow those funds come through, the funds can access, the FG can intervene and pay them that fund directly. This, some argue, will ensure that Section 162, which creates our joint account, doesn't appear to have been expunged or invalidated. What do you think about this perspective?
And may be correct, I mean partially, but when you look at Section 162, it simply says 162 subsection 6 creates a joint state local government account. But 7 says, once the money gets to that account, it shall be paid to the local government. It does not say the money will be kept or diverted or spent from at the joint account level. It said it shall go to the local government. And what the Supreme Court has said, in view of the abundant evidence that this money is being diverted from the joint state local government account, let it go to the local governments directly, in line with the letter and spirit of Section 7 and 162 of the Constitution.
So another issue that people have raised is about the ability of states to run their internal affairs. And that this judgment in many ways can affect that balance, where states now are not really in control of their local government, because for the people who believe this way, the argument is with this kind of autonomy, we can have all kinds of things happening at the local levels, and the state governors will be at a loss to be able to control that. What do you make of this assertion?
No, again, as I said, a lot depends on the Nigerian people. Right now, as the system is structured, it is difficult to talk of the autonomy of local governments. The state independent electoral commissions are manned by appointees of the state governor. And what they have done over the years is to manipulate the local government elections in a way that only the candidates of the ruling party will be declared the winners. Now, or as it is today, elected officials are whimsically dissolved and caretaker committees are appointed in their place. And one of the terms of the judgment is that whenever that happens, the money for elected local government will not be given to caretaker committees. So one way or the other, we're making some progress. Now, the state governments and local government will have to have some joint programs in the interest of the people. The state government is still going to decide what the educational program of that state is about. And of course, local government will be expected to fix some schools, tar some roads, even pay some workers. So it is not that state governments will not have any, I don't want to say control, will not participate, because Section 7, I think this is an opportunity for the state government to take advantage of Section 7(6), which provides that there shall be an economic board in every state to enable local governments to participate in the economic affairs of the state. Just like the state governments, state governors are members of the National Economic Council. But because that body does not function properly, that's the only body allowed by the Constitution to advise the president on the economy of the country. But because that body doesn't function, the IMF and the World Bank not only advise the government now, they impose their own economic agenda on the country. So for me, I think this case has to be studied. The judgment has to be studied by the governors, the local government, even the federal government, so that everybody will appreciate that what the Supreme Court has done is to promote public accountability at the grassroots level.
I mean, I think finally from me, we've been talking a lot about the economy and this money and, you know, the financial autonomy. Well, one thing that we haven't really talked about is the impact that this judgment will have on security in the states, because many people have blamed insecurity on the fact that local governments are not functional. Could you talk to us a bit about this impact?
Again, the local government now will be held accountable in many areas. They can no longer throw up their hands like Pontius Pilate. You know, now you have to be accountable. Since you are taking the money, you have to take care of security in each of the local government. And I think why this is going on, the federal government and state government have also agreed on state police. If you have state police, of course, the local government will also be expected to contribute some fund to the sustenance, you know, or maintenance of state police in each of the states. So there is no way that local government will now feel, oh, we now have a field day to do what we like with the money. And that is why I'm saying, I'm suggesting that the Nigerian people will have to take more than a passing interest in the affairs of local governments in our country. Ditto for state and whatever. So, and I also want to suggest state governments have no business quarreling with the judgment. What state government should do now is to intensify the struggle for a new minimum wage. I mean, a new revenue allocation formula that will allow them to have more money from the federation, federation account. Right now,
so, all right,
the federal government,
the governor of Adamawa State, we just all listened to him there, where he was accusing the federal government of not allocating or disbursing all the funds that are accrued. Isn't that the same thing that the state governors are being accused of? Because he's saying, accusing the federal government of withholding some of the funds that should have been disbursed to the states and local governments. Is that a violation of the law?
The governor Fintiri is right. But I have challenged state governors in Nigeria of abdicating their responsibilities to the federal government. Take, for instance, there are federation companies in Nigeria, including NNPC, LNG, MPA, NIMASA. These are federation corporations, not federal government bodies. But what has happened? The state government have allowed the federal government to manage this institution. In December 2018, the then Director General of Budget of the federal government, Mr. Ben Akabweze, did disclose publicly that the CEOs of federal government parastatals, federation parastatals, have withheld 10 trillion naira. Today, that money will have gone beyond 20 trillion. There was a time I went to court when I couldn't persuade the state government to insist that money collected from SEPAC fees, $2,000 per expatriates in Nigeria, totally about 40 billion naira. State governments were not interested. What happened? Federal government takes 30%, Ministry of Interior 7%, Immigration 5%. That's 42%. The remaining 58% goes to a contractor, a foreigner. And what does it do? Nothing other than to say, pay this money to federal government account. So I went to court. I won the case in December 2019. I've been trying to persuade state government, because the federal government filed an appeal. The contractor filed an appeal. I've been trying to persuade state government, apply to join the case. This is your money. Because the order of the court is that this money shall be paid to the federation account. The other one, in 2018, the Supreme Court, this same Supreme Court, ordered the federal government go and recover money, royalties, not paid by IOCs for 18 years. This money was to be paid under a particular law. So what happened? And that was my campaign. So what happened was that Rivers State Government, Akwa Ibom State Government, and Bayelsa went to court. In a judgment delivered in October 2018, the Supreme Court ordered the federal government, go and collect the money. The federal government set up a committee, the Buhari regime. The money came to $62 billion. When the federal government was not prepared to collect the money, Rivers State Government and Akwa Ibom State Government, under Governors Wike and Emmanuel Udom, went to court, went to the federal court. Justice Taiwo, now retired, gave a judgment to the fact that $3.1 billion from the $62 billion payable to those two state governments shall be paid by the federal government. So other state governments have not bothered. So these are the issues. So state government must now sit down. Now that we have started this campaign for financial autonomy for local government, let's also move to promote campaign for financial autonomy for the state government and the federal government. Look at the last one. Okay. Now, state governments have not even they are not interested in the ongoing dispute between the Dangote refinery owners and IOCs. Meanwhile, if we can have our own refineries, which were to have been commissioned in December, the refinery in Port Harcourt should have been commissioned in December last year, according to the president. The refineries in Warri and Kaduna are supposed to be commissioned this year. If these refineries are working, and Dangote refinery is working, and they can get crude to refine in Nigeria, the money being spent on importation of fuel now will be saved, will be banked, and there will be more money in the federation account in the interest of all of us. Okay. So that is why state government will have to be more proactive with respect to the management of the economy of Nigeria.
Well, Mr. Falana, this might be a little unrelated question, but would you say that with this judgment and all of this conversation we're having, the restructuring of the federation has started?
It's not just starting. Since 2001, the restructuring of the country by litigation started. In fact, but for the cases that have been won in court, some state government will have been bankrupt by now.
So how significant is this in the process of restructuring? Is this judgment of the Supreme Court on local government autonomy in the restructuring process?
The restructuring process is that under the current political dispensation, there are 3 tiers of government: federal government, state government, and local government. This judgment has now reinforced the autonomy of local government. Right? But what I'm saying is that we've gone to court to challenge, state governments have gone to court to challenge the conduct of elections by the federal government. And the court has said it's the business of the state. State governments have gone to court to say, thou shalt not touch the fund of local government. The state governments won. State governments have gone to court. Lagos went to court to say, sorry, I cannot go to Abuja or the federal secretariat for the approval of my building plan. The Supreme Court looked at it. It was a 4-3 decision, 4-3 justices, you know, to defend. And the judgment was that it is not the business of the federal government to interfere in the physical planning of every state. There are other cases. In fact, the last one last year was that Lotto business. The federal government has set up a body to say we are the only one that can control Lotto in Nigeria. The Supreme Court has said no. Lotto is not in the exclusive legislative fleet. It's a residual matter.
Okay.
So it belongs to state government. So the state governments have, through these cases, improve their own economy, and there are still many areas
just one
being
last
controlled by the federal government.
Just one last one in the area of implementation and on the long run. If you can make this response short, elections into local government. You referenced it earlier that the state independent electoral commissions aren't doing well enough. How do you see that progressing going forward?
Again, it will require our going back to the report of the Uwais panel. Justice Muhammad Uwais had recommended that electoral bodies in Nigeria, members of the electoral bodies in Nigeria, be appointed through advertisement. And those who are shortlisted will go to a body that will now recommend to the House of Assembly.
Okay, maybe it is. We're getting closer to that time when that law has to be looked at.
Yeah, that recommendation. Yes, in the interest of all of us, at the federal and state level, we must have independent electoral office.
Okay, thank you so much this morning, Mr. Femi Falana. Again, I'm pretty sure that the conversation goes on here and there. Mr. Femi Falana is a senior advocate of Nigeria. Thank you so much for your time.
Thank you. My pleasure.
Okay, are we talking about the same thing on Business Morning on Sunrise Daily or not? In it.